Yes.
Lordship, I beg to mention item number 16 on behalf of respondent Hinti Jairam, legal aid
16.
counsel.
16.
Yes, item number 16. This kindly the matter may be adjourned for today because leading counsel is a season out of station, and the matter may be listed for admission hearing.
No. Why this has been listed for orders today?
On last occasion, this is a criminal petition challenging the order passed by the learned judicial magistrate first class, whereby the husband has been
No, why this has been listed for orders today?
for it on last day it was fixed for order hearing.
We'll see.
Now he is out of the station.
We'll see. Let the matter come.
Yeah.
It's in order stage. You be there. We'll see.
My Lordship, I would like to mention item number 27. Your Lordship, the leading counsel is out of the station due to some reasons.
Due to?
From appellant.
Just because the council is out of station, it should be adjourned or what? What is the ground of adjournment, sir?
Your Lordship, due to some reason, he is out of station.
What is the reason? Just because the council is out of station, that cannot be a reason for adjournment of the matter. You must cite some good ground, good reason
Kindly
for adjournment.
Kindly, Your Lordship.
As a last chance.
Okay.
As a last chance of ground, I mean, without there being any ground for
listed
adjournment.
after 1 week.
On the prayer of Mr.
Jegao.
Jegao.
Yes.
Learned counsel appearing on behalf of Mr. Rakshap, learned counsel for the appellant, stated to be out of station, list this matter after 2 weeks. Jegao. Yes, next.
Your Lordship, I beg to mention item number 4, appearing on behalf of Mr. K. Tama. Kindly, matter may be listed for 23rd of this month. He could not appear due to unavoidable circumstances.
Which for the petitioner? Have you taken consent? Have
Even
you taken consent?
Yes, he also absent. I think he also absent. In last order also, the petitioner was not present.
Okay, on the prayer of MS so-and-so, learned counsel appearing on behalf of Mr. K. Tama,
Yes.
learned counsel for the what? For respondent number?
2.
Respondent number 2.
Fix for Your Lordship, kindly fix for.
No, MS so-and-so. Not on the prayer. MS so-and-so, learned counsel appearing on behalf of him, learned counsel for the respondent number 2. Submits that Mr. K. Tama
Your
has some
Lordship,
personal
kindly.
difficulty today, for which she phrased for listing of the matter after 2 weeks.
I'm appealing for state lordship here.
MS Elhage, learned additional PP, is present. Mr. Non appears for the petitioner. Having considered that the counsel Mr. The prayer for adjournment is granted. Accordingly, list this matter after 2 weeks.
Right.
Yeah, please, Lordship. Lordship, I beg to mention item number 1 on behalf of Mr. O. Modi, conducting counsel for the petitioner. Lordship, he is today is out of station.
What is this? What is this? Item 1.
Item 1, Lordship.
On the prayer of Mr.
Lordship, listed after 4 weeks, Lordship.
On the prayer of Mr.
N. Noble,
Learned Counsel, appearing on behalf of Mr.
O. Modi, Lordship.
O. Modi, Learned Counsel in the petition. List this matter after 2 weeks, not 4
Deeply
weeks, 2
obliged.
weeks.
May I, Lordship, I beg to mention item number 2 and 3.
2 and 3.
Yes, Lordship. On behalf of the conducting council, Aringo. Your Lordship, the conducting council is out of station for his personal difficulties. So kindly the matter may be listed after 2 weeks.
MS so Learned Counsel appearing on behalf of Mr. Aringo, Learned Counsel for the petitioners. Both this matter, petitioners. Submits that Mr. Aringo has some personal difficulty today. Mr. Therefore, press for adjournment of the matter for 2 weeks. Praise the Lord. Who appears for the state?
Yes,
So and so is present for the theatre language edition defeat. For the state is president. List the matter of 2 weeks.
Your there's also interim. Lordship, kindly the interim may be continued as well.
Please there, go for trial. Interim order. Was the list continue.
Obliged.
Deeply obliged.
May I please, my lord?
Yes.
My lord, I beg to mention item number 8, my lord.
Ah.
On behalf of BK Mahajan, my lord, all the engaged counsel in the matter, my lord, we have already retired from the matter, my lord. And
Sure.
the same has been notified to the petitioner through registered post on 18th of this month, my lord. My lord, the new counsel may appear, my lord. Therefore, my lord may fix the matter.
You are
after
no
2 weeks.
longer, you are no
Appearing.
longer in the, for the petitioner.
Yes, my lord.
It has been notified
Yes, my lord.
to
Through
the,
registered post.
to the petitioner.
Yes, my lord.
MS estimate, M. Karba, Learned Counsel to the Learned Counsel submits that the petitioner, the applicant, petitioner has already been notified as regards to the withdrawal from the case. On when?
On 18th, my
You
lord.
just give that date. On
18th
18th.
April 2025.
Therefore, she along with our associates are no longer in this matter. In view of the above, come on, let this matter be listed after 2 weeks, so as to enable the petitioners to take steps for engagement of some other counsel on his behalf.
Your Lordship, I'd like to mention item number 28.
28.
Your Lordship,
Yes.
I'm appearing on behalf of Mr. DSJ, Mr. M. Carter. 2 weeks time may be granted to file an affidavit, Your Lordship.
Affidavit.
Your Lordship, it's already been ready, but Your Lordship, some correction is to be done, Your Lordship. We have taken consent from the petitioner, Your Lordship.
On the prayer of Mr. Your
Yes, or K. Terry, Your Lordship.
K.
Terry.
Terry.
Yes, Your Lordship.
K. Terry.
Yes, Your Lordship. On behalf of DSJ, Mr. M. Carter.
Appearing on behalf of Mr. M. Kato, London, DSGI, President, 3 weeks further time may be granted to file affidavit.
Yes, Your Lordship.
Affidavit or what affidavit?
Your Lordship, affidavit in opposition, if I may, Your Lordship.
I will just say affidavit. Have you taken consent?
Yes, Your Lordship.
Next prayer. Prayer not being objected to then counsel for the appellant. Come on, let this matter be listed after 3 weeks. 3 weeks.
2 weeks, man.
You are seeking 3 weeks or 2 weeks?
2 weeks will be fine, Your Lordship.
Yes.
May I please, my lord?
Hmm.
Much obliged. My lord, I beg to mention item number 26, my lord.
26.
Yes, my lord.
Yes.
Leading counsel Deep Bangin is unable to attend court due to back pain, my lord.
Okay.
I have taken consent, my lord.
Mr. M. Doji, learned counsel for the learned counsel appearing on behalf of Mr. D. Pangi, learned counsel for the appellant, submits that leading counsel Mr. Pangi has some health issues, therefore press for listing of the matter after 3 weeks.
After 2 weeks, my lord.
After 2 weeks. It is also stated that consent has been taken from the other side. In view that this matter be listed after 2 weeks.
2 weeks, my lord. All right.
I'd like to mention item number 20.
20. Yes.
The leading counsel is out of station.
Hmm.
The park is out of station. So matter may be adjourned for 2 weeks.
This 20 and 21
Yes, 20 to 20.
on the prayer of MS.
Why Pema?
Huh?
Why Pema?
Why Pema? Learned counsel appearing on behalf of Mr. T. Tapak. Let this matter be listed after 2 weeks.
After 2 days, she was asking.
2 weeks.
2 days.
Weeks.
Oh.
2 weeks.
No, see, actually, this matter is liable to be lost.
No, this is, we have not passed any order.
Then
We have vacated the interim order.
yes, Lordship.
We have recalled the interim order. We have already recalled the interim order.
Yes, Lordship. But Lordship, only recall is there, Lordship. Is the suspension already will, it should be there, Lordship. Dismiss should be there. Dismissal should be there, Lordship. Because of recall, he again they have filed the IA, Lordship.
That's why until the time we pass an order, in IA we have not passed any interim order.
Lordship.
You proceed.
Yeah.
Huh. What is it? Let this matter be listed after 3 weeks. 2 weeks.
2 weeks, Lordship.
2 weeks. Huh?
Obliged, Lordship.
My lord, I beg to mention the item number 6. I carry on behalf of El Perme.
Yes.
The matter may be listed after 2 weeks.
Why?
My leading counsel is out of station due to some personal difficulties.
On the ground that Mr. El Perme being out of station due to personal problem, Mr. So-and-so learned counsel for the petition, press for listing of the matter after 3 weeks. Praise the Lord, list after 3 weeks. Huh?
My lord, on last occasion, your lordship, the petitioner has given further time to file additional affidavit, your lordship. But now today they have not appeared. No one is appearing.
What affidavit?
Your lordship, the settlement deed, your lordship.
So what is to be done?
For the ends of justice, your lordship may adjourn the matter for a week then.
Week.
For 2 weeks, your lordship.
None appears for the petitioner on call. Petitioners on call. Mr. Next, Mr. T at London Edition PP is present. Next one. It is noticed that despite repeated time, no, despite granting of time, repeated granting, despite the granting of time for filing affidavit, no affidavit has been filed on behalf of the petitioner. Till that. Please stop. in view that this matter be listed after 2 weeks. If no further steps is taken as granted by this court, by the petition, appropriate orders will be passed on the next date.
Deeply obliged.
May I
Yes.
please, my lord?
Yes,
My lord, this is an bail application, my lord.
yes.
My lord, in
No
this-
steps. Have you taken steps?
Yes, your.
Doesn't say-
Through registry, I have taken steps.
Hmm?
Through registry, I have taken steps.
Where it is? It's when?
Before 11/4/2025.
No, it says 11/4/2025 steps for service of notice upon response 2, 3, and 4 not yet taken.
Prior to, my lord, prior to 11/4/2025, I have already taken the step through registry.
How do you know? Office note says something else. Hmm?
On the same day, my lord, I have taken steps for upon all the 4 respondents. 1 has received and 3 are yet to be notified in this order, your honor.
Yes, where it is. There's no record office note.
I have also see the order, my lord, but in the office record, it is not available.
Hmm? So
I have already go through the orders.
So, how do you know?
My
You
lord,
go
I-
by the records.
My lord, I have already taken the steps through
Sir,
registry.
how do you know? Office says, you said before 11.
Yes,
It's 11/4/25 order says no steps have been taken.
I am also surprised from this order, my lord.
I am more surprised the
Yes.
way you are submitting. You have
Yeah.
seen the record and you still you
I-
are saying that.
I am going to confirm this again from the registry, my lord.
So what is to be done?
The matter will be heard on the last item, my lord.
Huh?
If it is considered, your honor, it will be heard after last item.
So I saying that the office has wrongly given the note.
Yes, my lord. I am sure the officer wrongly.
We'll take after some time.
Lordship, I pray for an Passover. The conducting counsel for the petitioner is on its way.
Hmm?
For Passover,
Passover.
for the time being.
Do you have the case diary?
I have a case diary, and your lordship, on our last occasion, the learned counsel has raised an issue on ground of arrest has not been communicated.
Hmm.
So that part is only to be adjudicated. If it is not communicated, then he is entitled to get bail, your lordship.
Hmm.
It will be amounting to violation of Article 22 of Constitution of India, as recently held by the Honorable Supreme Court, your lordship. That is a difficulty, your lordship. Otherwise, arrest memo, everything has
What
been
is
committed.
that? It's not been.
Ground of arrest, your lordship,
Has not been.
has not been,
provided.
and most of the police are not aware of it, your lordship. So, your lordship, in
That's
this,
the reason the Supreme Court has said, has held recently. So in this case also no ground of arrest has been
no, your lordship, it has not been communicated.
communicated. So
So, your lordship, if it is not been communicated, then he is entitled to be granted bail. However, your lordship, my further prayer would be, your lordship, in the guidelines which has been laid by the Honorable Supreme Court may be communicated through this court to the DGP, so that, your lordship,
it must be given in the order itself.
your lordship, it has not been communicated to all the state, your lordship.
It's your duty to communicate,
But that will be better if it is go from this court, your lordship.
provide them. It's a Supreme Court judgment.
Your lordship will find in para 21. And it has been further held that the arrest memo cannot be equated with the ground of arrest also, your lordship. This is difficulty here again. Even the arrest memo cannot be equated with the ground of arrest, your lordship. Even the, your lordship, the stationary bar will not operate if same has not been communicated, your lordship. Your lordship will find in 31 also, your lordship. That expect, your lordship. Information of arrest cannot be equated with the ground of arrest, your lordship. Your lordship, in para 31, it has been also, your lordship, held by the Honorable FX Court that information regarding arrest cannot be equated with the ground of arrest, your lordship.
Yes.
My lord, I have made certain compilation, my lord, to this effect, my lord. Altogether, 4 judgments, my lord,
Why 4 judgments?
relating to the same issue, my lord.
Why 4 judgment? Only one latest and nearest.
My lord.
Yes, you tell us the facts.
But in this case, I've been in custody since last 108 days, my lord. If I may take my lord to page number 16.
Huh?
Page number 16 is the FIR.
Yes,
If I may read, my lord.
yes.
Subject FIR against NDPS smuggler. At approximately 9:30 hours, reliable information was received regarding the movement of suspected smugglers transporting a significant quantity of cannabis. The informant reported that the smuggler were traveling from Khalaktan, West Kameng district, in 2 vehicles, leading towards Doimuk via Khalaktan Rupa, Tepa Sagali Road. Upon receiving the information, SDPO Doimuk City, so and so, along with SI so and so, and police station's ready party, immediately proceeded to the same road for interception. 2 vehicles were successfully intercepted at Sopo village. Number 1, Maruti Ertiga. This vehicle was found carrying 26 white plastic bags of suspected cannabis ganja, weighing total 145 kilograms. The suspected cannabis ganja was seized from the driver by so-and-so at 12:15 hours in the presence of executive magistrate and independent witnesses. The driver, identified as Sri so-and-so, son of so-and-so, residing at so-and-so, was taken into custody. Number 2, madam, escort vehicle. This vehicle was serving as an escort for the suspected cannabis ganja. Its occupants were apprehended and identified as follows. I am Dan Sharma, madam. I am Dan Sharma, serial number, the last one. For my vehicle, my lord, nothing has been recovered. The only allegation is that I have acted as an escort to the vehicle from where the contraband has been seized. There's no recovery from my possession, my lord. And since then, I have been under custody, and as of today, it's 101 days. Now, if I may take my lord to the arrest, my lord.
101
1 days, my lord, as of today.
arrested.
Arrested on 10/1/2025. Page number 21 is the arrest memo.
Yes.
Page number 28.
Hmm.
Serial number 7, my date, time, and place of arrest 10/1/2025 at 20 hours at Doimuk Police Station.
Hmm.
Now, I have raised this issue, my lord.
Hmm.
Unless and until, my lord, it is mandatory that a grounds of arrest has to be given to me and my relative, my lord, in writing
Hmm.
during the time of arrest, which has not been complied with.
Hmm.
And non-compliance of the same violates the statutory provision under section 47 of the CRPC, as well as article 21 and 22 of the Constitution, which entitles me for a bail rider. Keeping apart all the grounds, though nothing has been recovered from my possession, man, and the length of detention is 101 days. That is one leg of submission. The other ground is that, my lord, I'm right away entitled for a bail for non-compliance of the mandatory provisions under 47 of the BNSS, as well as Article 21 and 22 of the Constitution, my lord. To this effect, my lord, if I can place the first authority, which would suffice, my lord. First judgment, my lord. If I read from para 25, my lord. Page number 11. A constitution bench of this court examined in detail the scheme of Article 22(5) of the Constitution of India in the case of Hari Kishan versus State of Maharashtra and others, and held that the communication of the grounds of detention to the detainee in writing and in the language which he understands is imperative and essential to provide an opportunity to detainee of making an effective representation against the detention in the case. Such communication is not made, the order of detention would stand vitiated as a guarantee under Article 22(5) of the Constitution was violated. The relevant para is extracted herein below. Clause 5 of Article 22 requires that the grounds of his detention should be made available to the detainee as soon as may be, and that the earliest opportunity of making a representation against the order should be.
These are preventive detention.
No, madam, and other offences also.
Where it is.
It is mentioned down below, madam. In order that the detainee should have that opportunity, it is not sufficient that he has been physically delivered the means of knowledge with which to make his representation. In order that the detainee should be in possession effectively to make his representation against the order, he should have knowledge of the grounds of his detention, which are in the nature of charge under him, setting out the kinds of prejudicial acts which the authorities attribute to him. Communication in this context must therefore mean imparting to the defense sufficient knowledge of all the grounds on which the order of detention is based. In this case, the grounds are several, and the number based on numerous speeches said to have been made by the appellant himself on different occasions and different dates. Naturally, therefore, any oral translation or explanation given by the police officer serving those on the detainee would not amount to communication. In this context, must mean bringing home to the detainee effective knowledge of the facts and circumstances on which the order of detention is based. Now, down below, my lord, 26. Further, this court in the case of Lalubai, Jogibai Patel versus so and so laid down the grounds of detention must be communicated to the detainee in writing in a language which he understands. And if the grounds are not verbally explained, the constitutional mandate under Article 22(5) is infringed. The relevant para is extracted here. Communicate is a strong word. It means that sufficient knowledge of basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in the language which he understands. The whole purpose of communicating the grounds to the detainee is to enable him to make a purposeful and effective representation. If the grounds are not verbally explained to the detainee and nothing in writing is left with him in a language which he understands, then the purpose is not served, and the constitutional mandate in Article 25 is infringed. If I study my 21 is relevant, 29 money. The language used in Article 22(1) and 22(5) of the Constitution of India regarding the communication of ground is exactly the identical. Neither of the constitutional provisions require that the grounds of arrest or detention, as the case may be, must be communicated in writing. Thus, interpretation to this important facet of fundamental right as made by the Constitutional Bench while examining the scope of Article 22(5) of the Constitution of India would ipso facto apply to 22(1) of the Constitution of India, insofar the requirement to communicate the grounds of arrest is concerned.
Will you come to this? That's why I'm saying that the earlier constitutional bench is regarding the preventive detention.
No, my lord. Other offences
Two
as well as
plus 12.
preventive detention, my lord. Para 30, my lord. Hence, we have no hesitation.
No, that's what I'm saying. You have read this judgment which you have read and which has been quoted. This constitutional bench, Harkison's case,
Yes,
Harkison's case is with regard to Article 22(5),
yes,
and it's with regard to preventive detention. Of
Yes.
course, it has been clarified.
yes,
There are 29.
yes. And para 30, my lord.
Hmm.
Hence, we have no hesitation in reiterating that the requirement to communicate the grounds of arrest or the grounds of detention in writing to a person arrested in connection with an offence or person placed under preventive detention as provided under Article 22(1) and 22(5) of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody or the detention being rendered illegal as the case may be. Furthermore, the provision of Article 22(1) have already been interpreted by this court in Pankaj Bansal Supra, laying down beyond the pale of doubt that the grounds of arrest must be communicated in writing to the person arrested of an offence at the earliest. Hence, the fervent plea of the learned ASG that there was no requirement under law to communicate the grounds of arrest in writing to the accused appellant is noted to be rejected, my lord. Now, my lord, the relevant part is at page number 46, my lord. Para 46, my lord. Page number 15, my lord. May I read? We are of the firm opinion that once this court has interpreted the provision of the statute in context to the constitutional scheme and has laid down that the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes the law of the land binding on all the courts in the country by virtue of Article 141 of the Constitution of India. Now, coming to the aspect as to whether the grounds of arrest were actually conveyed to the appellant in writing before he was remanded to custody of the investigating officer. We have carefully perused the arrest memo, annexure P7, and find that the same nowhere conveys the grounds on which the accused was being arrested. The arrest memo is simply a performer indicating the formal arrest for which the accused was being arrested. Now, straight away, my lord, 51 paragraph, my lord, 51 and 52. As a result, the appellant is entitled to a direction for release from custody by applying the ratio of the judgment rendered by this court in the case of Pankaj Bansal Supra. Accordingly, the arrest of an appellant followed by remand order so and so also the impugned order passed by the High Court of Delhi so and so are hereby declared to be invalid in the eyes of law and are quashed and set aside. Though we would have been persuaded to direct the release of the appellant without requiring him to furnish bonds or security, but since the charge sheet has been filed, we feel it appropriate to direct that the appellant shall be released from custody on furnishing a bail bond to the satisfaction of the trial court. My lord, in such circumstances, my lord, I am entitled for a bail without a bail bond, my lord. In this case, my lord, only for a reason that the charge sheet was filed. That is the reason, my lord, to the satisfaction of the trial court. And similar judgment, my lord, continues.
Yes.
My lord, so far as the material against him, that will come on the later part, but still, your lordship, so far as the possession is concerned, the possession is not a mandatory requirement to attract the sections of the NDPS Act as held in the many cases by the Honorable Supreme Court. Because, your lordship, there is a constructive possession or concept of constructive possession is also there. It's all about, your lordship, the mental element coupled with the consciousness about the possession, having the knowledge. So this person has the knowledge that the other car, which is in front of their vehicle, that car is carrying that contraband substance, your lordship. And he was well aware of that, and he was part of that team, your lordship, which he has clearly admitted in his 161 statement. So sufficient material is there, and your lordship, is the quantity is a commercial quantity. So rigor of section 37 would have applied if the ground has not been violated, your lordship. That Constitution Article 22. That is the difficulty, your lordship. Because of that, your lordship, I cannot stress on the section 37 of the NDPS Act Because your lordship, the CD doesn't disclose anything about the communication of ground of arrest, your lordship. Because your lordship has rightly pointed out earlier, this issue was basically raised in the preventive detention, actually, in the first instance. Later on, it has been extended to the other offenses also. Your lordship, that I have already punished one judgment, your lordship. Here also, your lordship, in 2000 and recently also, your lordship, in 384, 420, 468, 471, 509, 120B of the IPC also, your lordship, the same judgment has been reiterated by the Honorable Supreme Court. And since non-compliance of the Article 22 and the Section 50 of the CRPC, your lordship, the accused has been released on bail, your lordship. Your lordship will find the paragraph number is not been given. In second page, your lordship will find the second para, we are inclined. The sections here are, your lordship, 384, 420, 468. We are inclined to consider only the last issue raised by the appellant with respect to non-punishing of the ground of arrest. Upon perusing Annexure P3, we can see that what has been provided to the appellant is only the arrest memo in the prescribed format, which is meant to be given to the appellant by way of intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of the co-accused. We are agreement with the submission made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be construed as a ground of arrest, as no other worthwhile particular have been punished to him. This being a clear non-compliance of the mandate under Section 50 of the CRPC, which introduced to give effect of Article 22(1) of the Constitution of India 1950, we are inclined to set aside the impugned judgment, particularly in light of the judgment rendered by this court reported in Procedural Purkastya versus State NCT. In view of the matter, impugned judgment is then set aside and the arrest of the appellant followed consequential remand order are also set aside. Here also, your lordship, even in the arrest memo, your lordship, if something worthwhile has been reflected regarding the ground, that would be suffice, no doubt, your lordship. It clearly reflects here other worthwhile particular. But here in this case, your lordship, in arrest memo also, your lordship, no ground of arrest has been reflected here, your lordship. And it is, your lordship, admitted fact that the IOs are not aware of this thing, your lordship. Unfortunately, your lordship.
You should make them aware.
Yes, your lordship. The only thing that the punishing of the arrest memo will suffice this purpose.
So according to you, there's no reasons.
No, your lordship. Arrest memo is only there, your lordship. The CD is there, your lordship. Arrest memo is it's also annexed by the petitioner in the, your lordship. Yes,
It's the same thing.
petition.
The
Yes,
same format.
yes, your lordship. And I personally, your lordship, communicate with the IO also. I personally communicate with the IO also, your lordship, because this judgment, your lordship, which I earlier punished, your lordship, this judgment doesn't say that it has to be given in written only. Orally also, it can be communicated for the purpose of Article 22, but it is upon the prosecution to satisfy the court that it has been properly compliance, Article 22.
How many accused are there? Accused persons are there?
Total, your lordship, five accused are there.
Five.
Yes, your lordship. Lakan Basmatari, Babul Nath, Praveen Narjari, the present applicant Dan Sharma, and Sri Sivadas.
Should be difficult to have this format arrest come inspection memo. This is arrest memo, right?
Yes, your lordship.
There's no column.
No column, your lordship. Otherwise, even if in arrest memo, if they have communicated the ground of arrest, that would suffice, your lordship.
Whether intimation is given to relative.
Yes, it's clearly written, yes. Intimation has been given, no doubt, your lordship. And it is the relative who has approached this court by filing this regular bail application.
This will be difficult.
Yes, your
If
lordship.
this is the case, entire investigation, I mean, no one will be able, I mean, no proper investigation will be.
Well, there are cases where, my lord, in the arrest memo, the grounds of arrest are being mentioned by the concerned IOs. I have come across lots of cases where the IOs usually mention in the last part of the arrest memo. One column is always there.
There's no column in this.
That is the reason.
In this case, your lordship,
Otherwise, there.
off record, your lordship,
Arrest memo, the forms are not similar.
check, your lordship, here in this case, checklist has been provided, checklist is there. I have been informed by the IO that their ground of arrest has been written, but that was not communicated to the accused. That is the again problem.
Where it is.
It has not been part of the record. That otherwise, your lordship may call for the checklist, but that checklist has not been communicated to the
No,
accused.
even if that is, it is there, it has to be communicated.
Yes, exactly, your lordship. That is the not communicated. That is the problem. Otherwise, your lordship, I would have made submission on that.
But it is not there.
It is not part of the
You
record.
call for that. Because it will have a ramification.
My lord.
As you said rightly, because this, if there's a form, and if it's not there, and if it's not reflected, or if it's reflected, even if it's not been, I mean, if it's reflected, if it's not communicated,
Yes,
you may have the ground.
Yes.
But simply just because, you know, it will have a serious ramification.
Yes, exactly, your
If
lordship.
you just,
Otherwise,
we'll just see and we'll pass the order.
see. My lord, may kindly peruse the case diary, madam.
No, it's a the
Checklist,
checklist,
checklist, yes.
but then it's not in the
But so far, my lord, my instruction.
grounds of arrest are there,
Right.
but it has not been communicated.
Communicated.
What that is what he said.
Right.
So you may be entitled on that, but we'd like to see.
Right.
I mean, if this is the only format, there's no grounds
Right.
to be mentioned.
Yes.
This cannot be done.
Yes.
It appears that this form is under section 233. What is CRIJ? I don't know.
CRIJ, Criminal Law General, your lordship.
No, what is this?
In arrest memo.
This memo is under which section?
It is the difficulty, your lordship. Even your lordship, in a hypothetical situation, if somebody has, there is an allegation against of murder, then that person will definitely aware that the police will come and arrest him the ground. But still, that has to be communicated as per the direction of this Honorable
But my
Supreme.
lord, this case, in fact, my lord, the issue must
See,
have been raised for the
NDPS,
first time.
NDPS case, it's not that simple.
Yes, exactly.
Of course, nothing has been recovered from your possession. But as I said, the conscious possession is also there.
Yes.
But
You are the part of the, you are the accomplice.
even keeping
Just
that,
because this has not been, no possession has been.
well, I'm
the-
not pressing on that, man. I understand that. But my ground is solely on the violation of. the
That's why,
statute.
that is the problem. The entire thing in the state will be difficult.
Yes, your lordship.
On the,
No, and proper investigation will be taken.
but my lord, the law favors me, man.
Can you, when can you produce it?
Your lordship, charge, it get,
The checklist, whatever,
yes, checklist, your lordship. Tomorrow, your lordship.
or thereafter,
Tomorrow.
tomorrow.
Yes, your lordship. Tomorrow I will communicate the IO, your lordship.
Since my lord, the prosecution has admitted that the state has not been communicated, my lord, that may be recorded.
Hmm?
Since the prosecution has admitted that the grounds of arrest has not been communicated to the accused person. that may be recorded. Otherwise, my
Your Lordship, tomorrow will be, my
There-
submission
there-
will be same only, even if it's not recorded, Your Lordship.
otherwise, my lord,
Heard Mr. J. Learned counsel for the applicant and also heard Mr. T. Learned addition for this. Mr. T. No, since the case diary does not consist of the complete arrest memo. Come on. Mr. T. Learned additional PP is directed to produce the complete case diary, including the checklist.
Checklist, yes.
If any.
Yes.
List matter on 22.
Obliged.
4/20.
Obliged.
For further consideration.
May I please your lordship?
Yes.
Your lordship, this is a bail matter. Uh, the accused person has been arrested on 17 February 2025. And the accused person is in the judicial custody for 60 days as on today, your lordship. Whereas the mandatory period of such offense is 60 days, your lordship. But till today, the investigating agency does not file charges. Therefore, the accused may be released on that.
Yes, PP. Where is the PP? Yes.
Item 10. Item 10. Your Lordship, we have received the case diary, Your Lordship, but charge sheet has not been filed yet. That is the issue here. 60 days cross, Your Lordship.
With the case diary.
Case diary is with me, Your Lordship. Section register is 21B. That is the intermediate quantity. Punishment is extended to 10 years.
So
He is entitled to default bail, Your Lordship.
it is habitual, he's involved in other.
Yes,
similar
other
cases
two
earlier
cases are also pending, Your Lordship.
Hmm?
Other two cases are also pending against her, Your Lordship. But in this case, Your Lordship, within 60 days, charge sheet is supposed to be filed, but not filed yet.
Your Lordship, accused person is a breastfeeding mother. She has
Okay,
8 months.
but you are involved. This has been, the commercial quantity has been recovered from her position,
Your Lordship, that may be in the early other case, Your Lordship,
not this case.
not this case. In this case, section 21B is also only there, Your Lordship.
Intermediate quantity.
The other section is not there. 21B only. There's a difficulty. The punishment is extended to 10 years, sir. Only.
What is to be done?
If it is, and then if you're ready to punish the bail, then Your Lordship.
If is, but
Also, all the judgments are these days in favor of the accused only, Your Lordship. But,
any judgment,
on the
any
NDPS.
judgment?
Yes, Your Lordship.
Rakesh Kumar Paul, Your Lordship.
Yes, Your
NDPS, on NDPS,
Pardon, Lordship.
on NDPS.
On NDPS, specifically on NDPS.
No.
Two copies?
Except in Your Lordship, commercial quantity and other the sections which has been mentioned in section 37 that
NDPS.
Raigor will operate. Where 90 days has been construed as 180 days. Your Lordship. Section.
Here 60 days.
Here 60 days. If it is extended to 10 years, the CRPC would apply, Your Lordship. BNSS, sorry. 187 would apply. Your Lordship may kindly directly come to section 21B, under which he has been booked. Punishment for contravention in relation to manufactured drugs and preparation. Whosoever in contravention of any provision of this act or any rule or order made or condition of license granted thereunder manufacture, possess, sell, purchase, transport, import, interstate, export, interstate, or use any manufactured drugs or any preparation containing any manufactured drugs shall be punishable. B. Where the contravention involve quantity lesser than commercial quantity but greater than small quantity with rigorous imprisonment for a term which may extend to 10 years and fine which may extend to 1 lakh. So if it is extend to 10 years, then Your Lordship, the section 187 of CRPC would come, Your Lordship. But if it fall under section 37, then it will be 180 days. But intermediate section doesn't fall under section 37 of the NDPS Act. In section 37, Your Lordship, the rigor will operate in section 19, 24 or section 27A and the offenses involving commercial quantity. In other sections, Your Lordship, the one that BNSS will apply.
1924, 27A. So 21B, 60 days.
Yes, 60. If it is extended to 10 years, then 60 days. If minimum is 10 and it may go to life or death or even more, but minimum is 10, it may go to 20, 30 also. There, 90 days, Your Lordship, which has been construed as 180 days. as per section 37 of the NDPS Act. Now here it would be 60 days. It's in 187 of the BNSS. Your Lordship.
Are Mr.
Tita Wing.
Then counsel for the applicant and Mr. T. Then additional PP for the state. By filing this bill application under section 483 BNSS 2023. The applicant has sought for grant of has spread for release of the accused, namely Srimati Sahida Khatun,
Yes, Your Lordship.
Yes, Your Lordship.
Elias Sahida Khatun, who has been arrested on 1702/2025 in connection with Bandadua PS case number 19 of 2024-25 under section 21 with bracket small b bracket close NDPS Act 1985. Yes, you come to page 19. Reasons and grounds of arrest. See, of course, it's not related here,
Yes, Your Lordship.
but about regarding earlier case.
Yes, Your Lordship.
Forms are not found.
19. Lordship.
Column page 19.
Yes, ground of arrest.
Yes.
It's
Column 10.
Here also is missing, Your Lordship.
Reasons and grounds of arrest.
Yes, it's not written here.
In some cases, their columns are.
Yes.
Here also you say it's question mark.
Yes.
What does it mean?
That means, Your Lordship, the question mark perhaps has been given by the council, Your Lordship, not by the police.
Then you don't have to write it. You don't have to mention here.
Yeah, they have to mention it, Your Lordship.
Then
I have concern. I
why
have.
this is blank? I think this is by the SI cause Taza.
Yes, Your Lordship.
Tada.
Yes.
Huh?
Yes, Your Lordship. They have to mention this reason of arrest, ground of arrest.
Yes. Then it would be an if it is communicated, utterance there. If you don't mention it, that's all. What's the question of giving this arrest memo?
Here also, Your Lordship, that means the column is there but not communicated, meaning there.
At least column is there in this case.
Yes.
Earlier case, even there is no column.
Yes, Your Lord.
No column.
No column is there in the earlier case.
Next, the next para, prosecution. The case set up by the prosecution is to the effect that on 17/02/2025, from a reliable information that one suspected lady has been transporting a huge quantity of narcotics drugs suspected to be heroin from Assam and selling to the and selling it to the local youths of Nia colony area at Bandadua district. Accordingly, same was intimated to the superintendent of police. In turn, directed the officer in charge of the police station, Bandadua, to constitute a team, and consequently, the police team laid a trap into so as to apprehend the suspected lady after identifying the location of the suspected drug peddler, Mr. After the compliance of the procedure come up, the rented house was thoroughly searched in the presence of the witnesses and recovered one green color soap case containing narcotic substances suspected to be heroin, weighing 10.23 grams. And one blue color soap case containing the suspected substance containing contraband substances suspected to be heroin, weighing 13.09 grams. Which was hidden inside the blue color bag from the bedroom of suspected drug peddler. Suspected drug peddler, the accused Srimati Saida Khatun. Accordingly, the accused was apprehended. The accused was apprehended from the rented house located at near colony Bandadua. Mr. Director, the Director, one SKC. Of police station Bandado as those there fire. List of which has been registered as Bandado base case number 19 of 2025 under section 21 within bracket B bracket close NDPS Act Strange on 1985. The accused Srimati Saida Khatun was arrested on 17/02/2025
And remanded on 18/2/2025.
and remanded on 18/02/2025 for 5 days. And now she's under judicial custody.
Yes, Your Lordship.
He is in judicial custody for more than
60 days, 62 days completed. Today is
63 days.
63 run running.
68 days by now. Mr. Next matter, Mr. So and so learned counsel for the petitioner submits that the accused is a lactating mother of 5 months baby. And the baby and she is facing even in human hardship inside the jail. And the baby is there's no one to look up to the baby. And listen, the baby is only to be looked after and taken care by the mother. Mr. Due to inappropriate atmosphere inside the jail, the baby also cannot be taken inside for the proper care of the accused. Mr. So-and-so further submits that since the offense alleged is under section 21B of NDPS Act, for which prescribed punishment is up to 10 years. And the investigating authority has failed to file a charge sheet within a prescribed period of 60 days. The accused is entitled to be released on default bail under section 187 within bracket 3 of BNSS 2023. Mr. Next matter. Mr. T at London additional paper.
Your Lordship, 1 April 2025, 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 1 April 2025,
submits that in view of the settled position of law, comma, the petitioner may be entitled for default bail as the investigation, as the police has failed to file the charge sheet within the prescribed period of 60 days under section 187 in bracket 3 of BNSS 2023 as the offense is less than commercial quantity and the punishment prescribed is up to 10 years.
Extend up to 10 years, sir.
Otherwise, the involvement of the petitioner as a drug pleader, the prime facie is clearly indicated and on our own statement of admission that she is involved in the alleged offense. Therefore, he submits that the court may pass appropriate orders as may deem fit and proper. That's all. That is what you are saying.
Yes.
Next paragraph. I have consider the submissions of learned counsel for the parties and also varies the case diary. The accused Srimati Sahita Katur was arrested on 17/02/2025 in connection with the aforesaid Bandha to appease case number under section 21B of NDPS Act and is still in the judicial custody. Admittedly, no charge sheet has been filed even after the lapse of 60 years as required to be done by the police. On section 187.
187 subsection 3 subclause 1.
BNSS
Roman.
BNSS 2023. Records reveals the next paragraph. No, not record. The materials on the case diary indicates prior involvement of the accused in dealing with the contraband substance, as she is also an accused in another case wherein another case involving commercial quantity, particularly Bandha police case number 16 of 2021 and Bipuri appeals case number 140 of 2023. However, since the police has failed to file a charge sheet within the prescribed period under the law, I'm on that. This court is constrained to this court is constrained to pass an order granting the release of the accused Srimati so and so in view of the on default bail. Accordingly, the petitioner, the accused shall be released. On bail, then with personal bond.
Maybe your lordship, the surety will be required because your lordship, perhaps she is not from this state.
Furnishing of surety to the satisfaction of what?
The special court, your lordship.
Special court, NDPS, UP. What to do? Just because of the default bail.
Yes, your lordship.
It's a
Yes,
it's
your lordship.
original. No,
It's a copy, but your lordship, that may be returned to us, your lordship, because otherwise it will be accessible to the other side. It's a CD, your lordship.
the return after some
Yes, your lordship.
after the this thing. You'll have to check something. Yeah.
Oblige, your lordship.
Disposal. Seven. Okay.
My lord, I have confirmed it from the registry office, my lord. But the person whom I have submitted the steps, your honor, today is absent, your honor.
Huh?
Today he is not available in the office, Mr. Bagra. So it is up to the court, your honor. I have to file fresh step in this regard.
So
Order may be passed for the fresh step, my lord. Because Mr. Bagra is not appear today in the office, your honor.
who is Mr. Bagra?
Office in charge.
Who is of
Registry office in charge, my lord.
hmm?
Registry office in charge.
Who is Mr. Bagra? A good advocate's clerk. Advocate's clerk.
Yes.
What are you going to do with the advocate's clerk?
Ah.
You said you have taken the steps. It's a fault of the registry that they have wrongly recorded in the office note that no steps has been taken.
Yes, my lord.
That is you wanted to confirm.
Yes, my lord. Because your honor,
What is the, what Mr. Bagra is got to do it?
my lord, I have submitted 4 steps for 1 respondent, 2, 3, and
Sir,
4.
he is an employee of the registry. Mr. Bagra is an employee of the registry.
As and when we file steps, my lord, through
Just
him,
recall yourself. You said the office note dated 11/04/25 is wrong.
My
Because
lord,
you have taken steps before 11/4/2025.
pardon myself, my lord, I have already filed my 4 steps. One is received by the our learned
Therefore,
PP.
we have granted you to confirm from the registry whether you have taken steps or not to any other person who is not the employee of the registry or who is not the.
But I don't know that he is the employee of registry or not, my lord.
Huh?
I don't know he is the office staff of the registry or not, my lord.
Then why you have said that this office note is wrong?
Because you know, as and when we file any petitions before this honorable court, we file a step in the hand of that person, my lord. Because he is sitting in the office, filing office.
Are you a lawyer or are you something else?
I am lawyer, my lord.
Then why you have said, when you say that this office note is wrong?
Be-
Because you said you have taken the steps already before 11/4/2025.
Yes, my lord.
So, when you have, from where you have confirmed it? You said you will confirm it from the registry. Why they have wrongly given this note on 11/4 when you have already taken the steps on before 11 April?
Because your
Then now you are saying that Mr. Bagra is not. Who is Mr. Bagra?
so far my knowledge, he is a office staff, my lord.
Huh?
So far my knowledge, he is a office staff, my lord.
No, he is a advocate's clerk. So, whether he's taken his steps or not, what the concern? It has to be the office has to maintain as per the records in the registry. If the steps are taken, it's recorded as taken, or notice issued. If it is not taken, it's not. But you say that this registry has made a wrong record. I mean,
Wrongly, my-
wrongly recorded that steps has not been taken.
Yes, my lord.
Then
Because, my lord, I have no knowledge that he is not the staff of the registry office.
you must have the knowledge how the steps are being taken and how the notices are issued. Of course, you may be a big lawyer, may not required to do that.
Next time I will take care of it, my lord. My lord, one thing I would like to draw attention of this honorable court upon the points, my lord.
It's a
If-
POXO matter.
Yes, my lord. As per the section 4 of subclause 9 of the rules of the POXO, my lord, each and every victim and informant must be heard before the court
So,
in each and every matter, my lord. But here in this case, if the honorable court find that the ground of arrest, which was earlier submitted by our advocates, Your Honor, the ground of arrest has been not communicated to the accused. He is since last 15 months inside the jail.
heard Mr.
MK Singh.
No, on the prayer of Mr. MK Singh, I'm not recording anything adverse over but this court is not happy. The way you are trying to take on the court. Don't make an, I mean, the easy, I mean, don't make an, allegations without confirming anything.
Oblige, my lord.
Without knowing anything, don't make a submission. All right? You have easily said that the registry has wrongly recorded that the steps has not been taken.
But my concern
You
is,
first confirm and make the submission. All right?
oblige, my lord.
You yourself doesn't know whether the steps has been taken or not. You have simply submitted your maybe copy of the petition for steps for notice to the advocate's clerk.
My lord, I have
It's
some,
between you and the advocate's clerk. Until that time, it is placed before the registry for issuance of the notice. Right?
Right.
Please careful. Be careful.
Oblige, my lord.
Further 3 weeks time is granted. The 7 days time is granted to Mr.
MK Singh.
MK Singh. MK Singh.
Yes,
M. Singh.
M Singh.
Learned counsel for the applicant.
Oblige, my lord.
Lordship, this notice may be routed through the office of the PP, Lordship.
Yes. The notice be routed through the office of the public prosecutor.
Oblige.
May I please, Your Lordship?
Yes.
Your Lordship, service report is still awaited.
Your
Okay,
service
respondent
report
of it.
list after 4 weeks. Mr. So-and-so learned counsel for the petition and MS Elhagi learned additional PP are present.
Lords, has item 12 been called out?
Yes,
Lordship, I'm appearing on behalf of M. Khatam.
yes.
Lordship.
You
this
have
matter-
filed the affidavit in opposition.
Yes, Lordship.
Okay. Who is responsible 2 and 3?
Lordship, I'm for respondent number 2 and 3.
Yes,
I'm for the state lordship for one.
none appears for the petitioner on
My lords,
court.
if
Yes.
I may, my lords, I appear for the petitioner in item number 12, my lords. On the
Yes.
last date of hearing, lords, there was a direction for the respondent number 2 and 3, that is the complainant informant, to file their affidavit in opposition. Lords, I have received a copy thereof. Lords, it can be fixed for final hearing on any date convenient to my lords after 2 weeks, my lords.
Heard Mr.
My lords, Anshuman Sahni. Yes, my lords.
Huh?
My lords, Anshuman Sahni.
Take the name. Anshuman. Please repeat your name.
My lords,
Anshuman
Anshuman
Sahni.
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 Please, my lords.
Sahni.
Oblige, my lords.
Anshuman. Yes, Sahni. Learned counsel for the petitioner. Miss So it's learned counsel appearing on behalf of Mr. M. Karthik, learned counsel for the respondent number 2 and 3. Submits that she has already filed the affidavit of opposition. So is El Hagelan and so is present. It's for admission hearing after 3 weeks.
My lords, may only fixed a date, my lords, because I traveled from outside Itanagar for the matter, my lords. If it's
We'll see.
convenient for 12th of May, my lords.
It's after 3 weeks.
My lords, may continue the interim order granted earlier.
Next. Interim
Because
order
there
is there.
Yes, my lords.
Interim
please, my
order
lords.
is there.
Please, my lords, 29th July 2024. my lords.
Okay, interim order passed earlier, sir, continue.
Deeply obliged, my lords. Deeply obliged.
My plea. My lord, here many occasions, respondent was failed to file affidavit in opposition.
Yes,
So,
what is to be done?
uh,
Notice.
sharing, yeah, on 3/11/2024,
Hmm.
the council appeared on behalf of respondent number 1, 2,
Which for
order dated 3/10/2024.
you inform him
So, I prayed for.
on last 2 occasions,
Yes,
neither you nor the respondents have appeared.
exactly.
So, what is the matter?
It's a order.
Regular first appeal.
Yes.
Against what?
Challenging order passed by the learned civil judge, senior division UPR,
What's wrong? What's
for
wrong?
not granting injunction to the suit property.
Then is it can you file a regular first appeal against that?
As per my understanding, yes.
Hmm?
As per my understanding, yes.
So are you really interested or not? Last 2 occasions you have also not appeared.
It's unaware because
Huh?
unaware because a limited case in the High Court. That's why sometimes we happen to miss.
Okay. So we'll grant the other parties further.
So let the order may pass for hearing. So I will try to inform the other party also.
Heard Mr. Titorum,
Tito,
learned counsel for the petitioner. No, appellant.
applicant.
I doubt may not be maintainable. Think about it. A regular first appeal may not be maintainable. Right.
Well, in that case, I will withdraw.
List of non appears for the respondents. List of further 2 weeks time is granted to the respondents to file their objection. On the next date, if no affidavit, no objection is filed, appropriate order shall be passed.
Highly obvious.
Yeah, I missed out this list.
Gotcha. Yes.
It's all for IA 54.
Yes.
This for IA 54.
Yeah.
Okay.
Our write up also.
They have given us. उसके बाद भी.
We'll say hearing
Only,
concluded.
only 2-3 things I'll clarify. Because Lordship may see paragraph 2.
Yes.
I've highlighted the fact that there are 3 more stages to go. Prior to that, they are seeking to inspect these documents.
Yes.
Namely, para 2, before production of original documents, that is in their position, order 13 rules 1. Then before settlement of issues under order 40, followed by presentation of list of witnesses under order 16 rule 1. These 3 stages are left. Then next para 5.
para 5. The two parts of Rule 93 highlighted. So far as the first part is concerned, that is Rule 93 1A to E.
Para 2, which one?
Para
Para 5.
Para 5.
Page 2.
Yes, page 2.
Your written synopsis. Yes.
So, Rule 93
1A to E.
1A to E of the conduct of election mode, that is part 1 we are calling. So the documents which according to us fall within the scope of part 1 are A, B, G, M, N, O, P, R, S, T, V1 to V40. Then the documents which fall under part 2, Rule 93 2A to B, we have mentioned these documents. Then in para 6, we have made it very clear, so far as documents falling within part 2 are concerned, we have no issues. We have no right to object. They can very well have the access. Then subject to fulfillment of their condition, it is between them and the returning officer. Then so far as para 8 is concerned, in para 8, my lord, we have pointed out the conditions which are required to be fulfilled before they are allowed to see the, before they are allowed to inspect the documents. We have given the respective case laws also, including the paragraphs. Then paragraph 9 is important. The submission, my lord, which I had made on the last occasion, that something they have to establish prima facie.
Yes.
We have referred to Chaitanya Kumar Aditya. It's a full bench judgment of the Supreme Court. 1976 3 SEC 97, para 9. Quote, this court in a series of decisions has held that an order for inspection of election papers cannot be made as a matter of course, and that it is only when, on the basis of evidence adduced, allegations of irregularity are prima facie established, and the court is prima facie satisfied that the making of such an order is necessary to do complete justice between the parties, that an order for inspection would be justified. Para 6 at page 99. Then, in paragraph 10, we have referred to their annexure 27 of the election petition, where they have given the list of the dead persons, non-existent persons, and the double voters. So, we have dealt with that aspect in paragraph 8. Lordship will consider that, Hari Ram's case. Then, in paragraph 11, we have referred to the principle laid down in Ram Sevak. Ram Sevak may not is the constitution bench, 5 judges. Para 7, Roman 2. But a mere allegation that the petitioner suspects or believes that there has been an improper reception, refusal or rejection of votes will not be sufficient to support an order for inspection. We say that even this specific pleading is not there. Even if such a pleading is there, that by itself will not be enough. First, to demonstrate, you establish your allegations first, and then we will examine as to whether you should be allowed to inspect the documents or not. Then, my lord, from para 12.1 to para 12.13, we have referred to each of the documents falling into part 1, and we have shown as to why these documents fall within the part 1. We have explained that. And lastly is the conclusion. And my lord, one more thing, we have made it very clear. Our objection is to their inspection of documents at this stage, quote unquote. Subject to whatever they establish, again, the matter can be relooked. Certainly, my lord, many of the documents falling in part 1 bound to be produced before the Honorable Court. They have to place all that. So, my lord, that is it, my lord, and nothing else. These are the things.
You have already given your judgment, copy of the judgments.
Copy of the judgments, no, my lord, we have not given. We have mentioned the citations.
We have mentioned it. Well,
Judgments we have not given. All the citations are given, including the page number and the paragraph numbers. Specific
so
quotations are
this
also
is
there.
his application.
Yes, that it is.
IM 54. Huh?
Yes. So, my lord, in this, my lord, in my written note, I have mentioned the 4 judgments my learned friend has referred earlier.
Yes.
So I'll just take very quickly. para one.
It's okay. I'll see it. We have heard you on that day.
It's like, I'm not reading out.
I said,
Yes.
accept any for clarification that may be so
Yes.
from this court.
Yes, very good.
With the understanding that no further
I'm narrating.
argument. We'll see, I'll check whatever is there. As usual, to the best of my knowledge and ability.
My lord has been doing a great job till now.
Yes.
He couldn't even muster courage to approach the Honorable Supreme Court.
Had Mr. Rituraj Biswas. It's his application only. And Mr. DJ Kapil, learned counsel for the applicant of the election petitioner. And also heard Mr. P.K. Tiwari, learned senior counsel assisted by E. Menjo, learned counsel for the opposite party. Respondent. Hearing concluded. Order reserved.
In the meantime, should we also draft issues? Should we prepare?
Let us not be rushed, since you are getting.
On that also,
already.
Because
Well, I'll try.
I have already pointed that out.
And we'll fix it after when.
Subject to my lord's convenience and
Yes. Let us be, frank, fair and frank that at least 1 month.
my lord will have to look into this aspect. And my lord, because this is an area I have
Yes.
found fairly contested.
Today is 21. May 21, something like that.
May I give a special? The documents which my valid friend is not objecting to. That document will also may commit us to.
No, but I mean, that's
No, if it's not objection, we'll not say anything on this. All right.
With the order file.
No, you may approach it, will not, until the time we pass an order. This is your application,
No, we
we
might
heard
not,
you. And since he has no objection to those documents falls under the part 2 of 93, you can always. It's up to you. No. Yes. That I'm not passing anything.
All right.
Any
So
order.
next day.
You just suggest the date. Within a month.
21st May till now is blank.
Or else.
My slot is blank till now.
Not exactly 21st. Make it the 19th.
19 also is blank in my
Yes,
case.
19 of May. Just mean this, hearing concluded, no? Order reserved, huh? We'll notify. You marked somewhere in the 19th. All right.
In our Guwahati High Court, may not possibly this is the first occasion,
You did.
this issue.
Okay. This issue. Okay.
Great, sir.
In that case, order reserved. That means, we'll not fix the date, we'll notify it.
All right,
With
all right.
an understanding that it will be on 19.
All right.
No, it will not, we'll fix the election petition on 19. All right. In election, this is in the IA. All right. IA will not give that date. In election petition, heard Rituraj same, for election petitioner and we get the same, list matter on 19/05/2020. That will be better.
Your
Yes.
Lordship, in this case, the step has been taken.
Huh?
Step has been taken, completed, and all the argument has been completed. Pleadings,
This is what? Criminal
a
petition.
criminal petition challenging the order passed by the JMFC.
Why state is not a party? Why
No,
state is not a party?
This is a maintenance case.
Huh?
This is a maintenance case.
Okay. What about respondent number 2 and 3?
One is the mother, and 2 and 3 are the two minor son.
Okay, represented by respondent
Respondent number 1.
One.
Yes.
Okay. So you are appearing for this,
I'm on behalf of Hinti Jaram. She's a legal aid counsel.
for respondent number one.
Respondent number 1.
Okay. So you are seeking time.
No, I'm seeking time.
Who is taking time?
I
You
am.
heard Mr. So and so learned counsel for the petitioner.
Your Lordship, since
MS, Re-
Diril.
Rilung, learned counsel appearing on behalf of MS H. Jeram,
Jaram.
learned legal aid counsel for respondent number 1. Submits that. Why? She has some difficulty today.
Actually, she's out of station.
Yeah. Submits that MS Jeram, learned legal counsel, has some personal difficulty today, for which she prays for listing of the matter after
On
3 weeks.
Your Lordship, since this
day after tomorrow, on Wednesday.
witness so that may be given, since this maintenance case, every month, every first day of the month, the interim amount is being deducted from the salary of the petitioner.
So what,
Therefore, Your Lordship.
you are the husband.
Yes, I'm the
You
husband.
pay, will increase the maintenance interim amount. How much you are paying?
25,000.
You are a,
Yes,
which you are working as
working as a IRBN, but there is other liability that I'm paying.
IRBN.
Yes, IRBN.
Yeah. What is the salary? Gross
The
salary?
gross salary is 60,000, but however, I'm
We'll
paying.
make it 30,000.
Your Lordship, that will be very high. Even the 25,000 is very high because I have lots of liabilities.
Then 35.
No, Your Lordship, that is very high amount.
When?
Wednesday.
Wednesday.
No, adjournment of the matter. Huh? Please, the prayers allowed. Huh? Please, as agreed to by learned counsel for the party, let this matter be listed on Wednesday. 23.
Wednesday.
23. 23/04/2025.
For admission hearing.
For admission
For admission hearing, Lordship.
For admission hearing.
Yes.
Okay. We are fixing it on Wednesday to enhance. 25 is too less.
No, Your Lordship.
My soul.
Yes.
My lord, I'm appearing for all the respondent.
Okay.
My lord, today I'm filing my wakalat nama.
Okay. Office note dated 11/04/2025 indicates that service report in respect of respondents have not been received back. Mr. However, Mr.
NUB.
N.
UB.
UB.
Yes, sir.
Learned counsel for the learned counsel enters appearance on behalf of all the respondents. Mr. Therefore, service in respect of no form, no, therefore the service in respect of no, it's okay. Mr. Therefore, parties, respondents are duly being represented by the learned counsel.
Yeah, please. Lord.
Mr. So and so, learned
And no.
counsel for the petitioner.
Yes.
Is
No,
present.
Lordship, there is an interim order that let
List
it
for
continue.
admission hearing after 2 weeks.
My lord,
Interim order passed.
3 weeks,
earlier,
3 weeks, my lord.
3 weeks. Interim order passed, earlier still continue. Yes.
Deeply obliged.
Yes.
I'm for the petitioner.
Why this been listed? Why this has been listed today for orders? Okay. You are appearing for
For the
respondent.
petitioner.
Who is for respondent?
I'm for respondent.
How many? All the respondents?
Yeah, only one.
Huh?
Sole respondent.
There is only one respondent.
You don't give here. You file it in the
Registry.
appropriate registry. Heard Mr. So and so,
And
learned
I don't
counsel for the petitioner. Next para. Although office note, no, office note indicates that office note that is 110425 indicates that service in respect of sole respondent is not received by, comma, Mr. So-and-so enters appearance on behalf of the sole respondent. List for admission hearing after 2 weeks. Huh?
Other posting maybe.
Why?
Other trial, otherwise it will go on.
What is this?
I have challenged the order, impugn order, on the point of.
Are you ready?
No, this time no. 2 weeks, that time may be given, Your Honor.
We'll hear.
That it will file.
Yeah, second time.
Second.
That's it.
Till next date.
No.
Other way.
Without hearing them, how can, why you have not, why no order was granted
On the
that
last
day?
date, Lordship, on the last date, it was directed that my.
Therefore,
my
step
prayer
will
for
be
interim order will
considered
be
the next
considered on the
date
next.
fixed. Okay. So, since he is entering appearance, are you ready today?
No.
We'll hear you.
After 2 weeks.
Huh?
After 2 weeks.
Not after 2 weeks.
Yes. It's may be.
Either we'll hear you for,
My senior. Okay.
we'll hear you interim, for interim prayer today or after 2 days. 2 days,
After 2 weeks.
not 2 weeks. And then we'll stay this impugn order.
My lord, I,
What is the impugn order? Page,
yes, my lord.
huh?
It is page number. Page number 41, man. And suit is clearly barred by the
Complaint
legislation.
is not filed in accordance to the respondent has made no specification as to how the instance suit has to be resolved. There is also no development from the whether the defects in values and the state is not be found in the policy law. So not be considered. No, the maintainability of the plaint has been rejected.
Yes, sir.
You have raised the maintainability.
Yes, sir.
So,
I filed a petition under order 7 rule 11.
Hmm.
And that petition was rejected by the learned trial. Thereafter, I challenged that order. The suit was, since the suit is very clearly barred by the law of immigration. To call in fact, Lordship, may I please, 1 minute time, my lord.
no, he's not ready. There's no point. We'll hear you, both of you, and file the order. When?
So, for 2 weeks only.
2 weeks. After 2 weeks.
No, we're not passing any order. You have not, huh?
No, my submission is, Lordship, at least for 2 weeks, further proceeding may be stayed. At least for 2 weeks, my lord.
What do you say?
No. I will object that and after the listing on the same date, I will submit our objection petition.
I undertake to conclude the hearing on the next.
Huh?
I will conclude the hearing on the next. If they are, if they come prepared, then I will also complete the hearing on the next. After 2 weeks. For at least till next.
No. Where where for passing an interim order? Where on your interim prayer? So he's not ready. He's saying, we'll give you 1 week time, not 2 weeks, for consideration of the interim prayer. All right. What was the order?
My lord, 1 week time will be too much less. I am outstation coming from Tinsukia.
Then,
yes.
Then, when do you want?
2 weeks we will give.
Not 1 week. A listed matter after 2 weeks. First order, what is the first order? However, I have not said, we have not said although, no? We just said office note indicates so and so. Huh? Then in that case, you just put comma, however so and so. Mr. So and so enters appearance on behalf of the respondent. Sole respondent, right?
Yes, sir.
Mr. As agreed to by the learned counsel for the parties, let this matter be listed after 2 weeks. All right. On the next date, the prayer for interim shall be considered. All right, that's what. What about 29? We'll complete the orders.
Lordship,
Next call is
Item 19. Your Lordship, record has not been received, Your Lordship. The appeal pending before the learned trial court has been called for, Your Lordship, appellate court.
item
19.
19.
Yes, Your Lordship. Otherwise, it's a, Your Lordship, post-conviction quashing, Your Lordship, on settlement by husband and wife.
Record is not received.
Yes, Your Lordship.
Heard Mr. Learned counsel for the petitioner and Mr. T at the London additional people for the state. Office to send reminder. The registry to send reminder for records, huh?
Yes, Your Lordship.
Records.
Obliged.
After 4 weeks.
Obliged, Your Lordship.
Lordship.
Yes.
Lordship, this is a criminal petition jointly filed by the informant, that is petitioner number 3, and the 2 accused, that is petitioner number 1
1
and 2. Yes, Lordship, for setting aside and quashing of the GR case number 3.
Fixed for admission, huh? Earn MS and so learn counsel for the petitioner.
Yes, Lordship.
And Miss MS L Hage learn additional provision. List for admission after when? List for admission hearing on when? After a week.
No, Lordship, this week.
Record is there. Record is there.
record is already here, Lordship.
Then when? Thursday.
Lordship, 25.
25. 25 is Friday. Make it 24. 24 0 for 20. This.
Like Lordship.
What is this IA for?
Your Lordship, this IA is for quashing of trial which is pending against me.
Praying for staying the further proceedings so and same is pending with judicial magistrate. What does it mean? Huh? What about that? Why this? There's no order.
Your Lordship, this main quashing application was listed on 10/04/2025, but inadvertently we have missed out this prayer for staying, Your Lordship.
When did you file this application? When you have not mentioned, when you have not made prayer in while the criminal petition was moved?
It was moved on, Your Lordship, it was listed on 10/04/2025, quashing
So
application.
why you did not pray for stay of the proceedings? Why separate application is required?
Your Lordship, we inadvertently miss out that prayer portion, Your Lordship, in that prayer portion.
They ought to have amend their petition, Your Lordship. Otherwise, for IA also notice has to go, Your Lordship.
I also will have to issue notice. You are unnecessarily creating problem for you. Have you taken steps? You have not taken steps also. In criminal main petition also you have not taken steps.
Yes, Your Lordship, we have taken.
We'll say. In the IA issue notice. Huh? No. I heard Mr. So and so learned consent for the petitioner.
Your Lordship,
petitioner. This is an application praying for a stay of the further proceedings of the, what is the case number?
Yamali PS case number 10 of 2019. GR number नहीं देखते.
Which is, where is it? It said magistrate's first class concert.
Yes, Your Lordship. GR number 74 of 2019. In Deomali PS case number 10 of 2019.
What is it? What is this?
State versus Neeraj Singh versus N. Mudit Mohan.
What is the name of the case in before the court? Number of the case? Deomali? What is it?
DML.
DML.
Yes, Your Lordship.
Deomali.
Yes, Deomali. Deomali PS case number. Your Lordship will find in annexer 4, the detail is there in the heading, Your Lordship.
Annexer 4 where?
Yes, Your Lordship.
Of
main petition.
page
48, Your Lordship.
48.
On top, Your Lordship will find in court of JMFC Konsa. State versus Neeraj Singh and Mudan Dixit. GR number 7.
GR number
Yes.
of GR number 74 of 2019 under section 120B 40 420 468 /34 IBC pending before the judicial magistrate first class.
Yes, Your Lordship.
Judicial magistrate first class. Konsa or Demali?
It's written Konsa, Your Lordship.
Konsa. Bishop issue notice returned by 3 weeks. Mr. Learned State Council enters appearance and accepts notice on behalf of respondent number 1.
Yes, Your Lordship.
Lordship, I would like to submit that there is an urgency in this.
Therefore, no formal notice need be sent. Listen. Mr. The learned counsel for the petitioner to take steps for service of notice upon respondent number 2.
Your Lordship, there are 2 and 3, Your Lordship.
Respondent 2 and 3 by registered post so.
Lordship.
In criminal petition, that is in IA, in criminal petition, ordered office note that is 11/04/2025 reflects that no steps have been taken by the petitioner for service of notice upon respondent 2 and 3. Mr. On the prayer of Mr. So-and-so, then counsel for the petition. Further 2 weeks time is granted. I mean, 1 week, further 5 days time is granted to take press steps for service of notice upon respondent number 2 and 3. You take press steps where we should notice in your IA, we'll consider it next step. All right.
Lordship, actually, urgency of the matter is.
Thank you. Notice has been issued. You have to take steps.
First steps then.
Even after issuance of notice, 1 month, I mean, nearly, let's see what it was. On 10/4, you have not taken steps.
Steps will avail.
You take steps. We'll see. What is the urgency?
Oblige, Your Lordship.
3 weeks, 3 weeks. What the case will be? We'll take it out. It's hearing, right?
They are seeking time.
Lord, sir, I'm from the petitioner side. My senior, he's out of the station. So time may be given.
On the prayer of Mr. MS D.
Really.
Rilum, learned counsel, appearing on behalf of Mr. M. Perthin, learned senior counsel for appellant, list this matter after 3 weeks.
3 weeks. Deeply obliged.
What is this?
It's a POXO matter.
2018 matter.
It's a POXO matter, Your Lordship.
Then we'll make it 2 weeks.
Okay, your lordship. Deeply obliged.
Item 29 is there. Anybody is reading? Are you ready?
I'm ready.
Yes.
And for the respondent number 2, my lord.
So-
Last week I was actually appointed for my receipt. So I didn't receive any copy or any paper.
So, what's the
We have taken a step. my
offense?
lord. We have taken a step, and along with the step, we furnish everything.
No, she has been appointed as legal aid counsel
So, yes,
for respondent number 2.
respondent number 2.
My lord, there is a paper book. So she can also collect it from the registry.
Well, I'll direct the registry to heard Mr. Swenson, learned counsel for the petition. Appellant. Mr. You are appearing for state you are. Mr. T. Learned additional PP for the state. Is present. MS. Learned counsel who has been appointed as legal aid counsel for respondent number 2 submits that she has not been provided with the relevant the required documents, including the paper book. List of in view of the book. Registry to furnish the copy of the paper book to the legal aid counsel, MS Permit. List the matter. You are coming from Tinsukia.
Yes, my lord.
After 3 weeks.
2 weeks there will be there.
2 weeks or 3 weeks?
2 weeks.
2 weeks.
Because my
As
client
agreed
is
to
there.
by learned counsel for the parties, this matter will be listed
My lord,
after
my
2
lord,
weeks.
there is one another IA is there.
Huh?
IA is
For
there.
bail.
For bail.
It's listed for hearing, we'll consider everything.
Go for disposal.